Good morning, good afternoon, good evening, wherever you are. I'm Yuri Nemitz, an attorney in private practice and a managing member at Nemitz PLC, a law firm based in Washington, D.C. This is the second of a webinar series dedicated to the problem of Interpol abuse and defending the rights of individuals on the international wanted list. My co-panelist today is Dr. Anna Ömehen, an attorney in private practice in Germany and the managing partner at Ömehen International, a law firm based in Berlin, and also teaches us at University of Gießen in Germany. Unfortunately, Nicola Canestrini, who is supposed to be our co-panelist today, is not able to join us. He's attending an emergency hearing in a criminal case for one of his clients. During our first webinar, Nicole and I talked about two important provisions in the Interpol Constitution, which we usually invoke when we represent our clients before Interpol. We talked about Article 3 of the Interpol Constitution, which strictly forbids the organization from engaging in any activity of a political, religious, racial, or military nature. And we dived a little bit into Article 2 of the Interpol Constitution, also a very important provision that says that, among other things, that Interpol must act in the spirit of the Universal Declaration of Human Rights. Today, we're going to talk more about Article 2. Both Article 3 and Article 2 are very extensive topics, and they merit more than one discussion. So we expect that we will keep going back to them during our future webinars, because the Interpol, so-called Interpol case law, in terms of Article 2 is mainly developed by the Commission for the Control of Interpol's Files, a tool, the main tool in the Interpol redress mechanism for the victims of Interpol abuse. We will also talk about the Commission today. So again, Article 2 of the Interpol Constitution says that among Interpol's aims is to ensure and promote the widest possible mutual assistance between all criminal police authorities within the limits of the laws existing in the different countries and in the spirit of the Universal Declaration of Human Rights. The same idea is included in the Interpol rules on data processing, which is, again, one of the main sources of, let's call it, Interpol law. And it says that data processing should be authorized with due regards for the law applicable to the country's source and should respect basic human rights in accordance with the Universal Declaration of Human Rights. Interpol has pointed out that both Article 2 and Article 3 act in unison to limit Interpol's activities to ordinary law crimes. In other words, they intertwined, and we often invoke both Article 2 and Article 3 when we argue our clients' cases before Interpol. I think that Article 2 should be split in two parts when we discuss it. First of all, it mentions, as I already mentioned, the laws existing in the different countries, and then it mentions the Universal Declaration of Human Rights. It's also interesting that the rules of data processing authorize, not really obligate, but authorize the Interpol General Secretariat to compile repositories of practice on both Article 2 and Article 3. So far, the General Secretariat has only published a repository of practice on Article 3, which is a very interesting document, and it does provide a very good insight into how Interpol interprets Article 3. However, the General Secretary has never compiled a repository of practice on Article 2. Nevertheless, as I already mentioned, the Commission for the Control of Interpol's Files has stepped in this regard and has actually developed a pretty extensive pretty extensive case law on Article 2. Even though, although Article 2 mentions the Universal Declaration of Human Rights only, specifically as an international instrument regarding human rights, the Commission has indicated that it applies other major international treaties concerning human rights as well, and that includes the European Convention on Human Rights. It's the jurisprudence of the European Court of Human Rights, American Convention on Human Rights, African Charter on Human Rights and on Human and People's Rights, the United Nations Convention Against Torture, and the jurisprudence of the United Nations Human Rights Committee. In other words, its practice in this regard, the Commission's practice, is really extensive. It is also important to remember when one argues a case before Interpol invokes Article 2 is that the Commission applies pretty much the same analysis to alleged violations of these human rights in the context of Article 2. And what it does is that it considers all relevant information to determine whether the individual has convincingly demonstrated the likelihood that a flagrant denial of human rights occurred or would likely occur. It does not take simple procedural irregularities as a flagrant denial of human rights or violation of Article 2. In other words, in invoking Article 2 of the Interpol Constitution, and therefore in international instruments such as the Universal Declaration of Human Rights, it's important to remember that the violation must be flagrant, very serious for the Commission to take it into consideration. In terms of the Commission's case law, the Commission has applied a number of provisions from major international human rights instruments, and that includes the right to due process and fair trial, freedom from torture and degrading treatment, freedom of expression, assembly of an association, the right to participate in government and free elections, the right to free movement, freedom of belief and religion. The Commission has opined on conviction in absentia, on death penalty and life sentence, and on right to health and security in the event of sickness. As I said, this practice is very extensive, so we won't be able to cover it in just one webinar today, or maybe in the next webinar if we devote it just to Article 2. But we will discuss all of this rules in detail during our future webinars. The second element, or the second part of Article 2, is that Interpol must act within the limits of the laws existing in the different countries. And this is when, unlike the first part of Article 2, unlike the Universal Declaration of Human Rights, the Commission hasn't really opined much. So this second part of Article 2 remains somewhat a mystery in terms of how Interpol should apply it. So my understanding of, and again, it's not based on really any case law because the Commission hasn't really opined on that, is that I think it's perfectly fine to invoke that a government has violated the provisions of its own national law, again, in the context of major human rights instruments. But again, I think that the standard that the Commission would apply, or probably already applies, is similar to the one that it applies to that I just mentioned in terms of the first part of Article 2, which is it must be a flagrant violation of national laws. What is it possible to invoke something that's not specifically provided in international human rights instruments, but is topical or characteristic in terms of national laws only, and argue that it's flagrant? I believe yes, but again, we really don't know much in terms of how Interpol is going to apply that particular part of the Interpol constitution. That is, that Interpol must act within the limits of the national laws of its member countries. So again, the jurisprudence, the case law, that the Interpol case law related to Article 2 is mainly developed by the Commission for the Control of Interpol's Files. And I will ask Anna to talk about the Commission now. Again, the Commission is the main tool in the Interpol redress mechanism designed to defend the rights of victims of Interpol abuse. The mechanism includes other tools, but we will talk about them later in our future webinars. Anna, if you please talk about the commission, and then we'll discuss that.
Okay, thank you, Yuri, very much. Can you hear me well?
Yes, yes.
Yes. Maybe just before I start to go into the topic, to give the audience an idea how long this whole webinar is going to be, I think we agreed that we will be 45 minutes, 1 hour in total. So
Yeah, we'll probably.
I won't speak 45 minutes. I will just speak
Yes,
10
we'll
minutes
probably
now.
talk for about half an hour. That's what we usually
Yeah.
do, and then
Yeah.
we'll do a Q&A if there are any questions. Maybe another 15 minutes. So yes,
Yeah.
thank you very much for reminding me of that. Yes.
So if there are any questions now with regards to my presentation, I'm going to show you a very brief presentation on Interpol's Commission for the Control of Interpol's Files. Please feel free to send us questions through the chat function in the streaming. Okay, I will now share my screen. Commission. Please feel free to send us questions through the chat function in the streaming. Okay, I will now share my screen. Commission. Okay. So to give you a small background on the history of the Commission for the Control of Interpol's Files, or briefly called CCF, it was actually started in 1982 already, when the General Assembly adopted the rules on international police cooperation on the control of Interpol's archives. However, it took 3 to 5 more years to implement the legal framework of the CCF by adopting the rules on the deletion of police information held by the General Secretariat. Then in 2003 to 5, a new set of rules, the RPI, Rules on Processing of Information, and the new rules on the control of information were introduced. And only in 2008 were the first operating rules established, which made the CCF an officially recognized independent supervisory body of Interpol. The rules of on the processing of data were only adopted 3 years later, and until then there was actually no remedies, and this was highlighted by Fair Trials International in their report Strengthening Human Rights and Strengthening Interpol, and they did a lot of lobbying, negotiations, discussions with Interpol, and this led to improvements with regards to due process and remedies, so that in 2013, 15, the refugee policy was adopted. Since then, the Interpol alerts of refugees are no longer published. So before they were published, in order to protect them better. And it was not until 2016-17 that actually effective legal remedies were established against the red notice, so the international arrest warrants were introduced through a new statute for the Commission of Control of Interpol's Files and new operating rules. So I see there has been a question.
I suggest, I'm sorry, and I suggest we take questions at the very end, because otherwise we'll be.
Okay.
Yeah, please go ahead. I think we should discuss the commission first. Please continue asking questions. We will try to answer all of them at the end during our Q&A. I do ask you, please kindly limit your questions to the topics that we're discussing today. If you have questions that are not covered by today's topics, I mean, you can still ask them. We'll try to answer them during our future webinars. Please go ahead, Anna. Thank you.
Okay, thank you. So the most important reform, that's why I highlighted it also, or bold printed it, was actually the reform of 2016. And by that, applicants have now a real tool to request deletions and access to Interpol's files on their personal data. In 2019, the operating rules were also updated and the independence of the CCF was further strengthened. Yeah, how independent is the CCF? Just back to the major changes in 2016. So the CCF decisions have now become binding. Before they were just recommendations. And the CCF was reorganized to ensure that complaints are handled by legal experts with expertise in human rights. So they have a better organization, better staff working on this, or more expert staff. And the rules on disclosure were changed so that countries now need good reasons to withhold information. The point is maybe to give you a better idea, Interpol is like a association. It's a membership association. So of 195 countries who are members of Interpol. So the problem from a human rights or defense lawyer's point of view is that obviously they need to keep good relationship with all their with all their members, and because of that, they usually coordinate with their members when there are requests on, for instance, a deletion request. They have the right, they reserve the right to touch base with the country that requested that Interpol red notice or diffusion, and check with the country whether the request is funded, what was the reasons, etc. And countries can ask Interpol to keep information confidential and not disclose it. So this change in 2016 was very important because since then they cannot just always say don't disclose, don't share with the requesting, with the applicant, but they need good reasons for this at least. And this has actually really increased transparency of the CCF. Another very important change was the timeframes were introduced. It's still very long timeframes. It's about 9 months the Commission has to decide on a deletion request, for instance. But it's at least progress that this is the time limit and the CCF tries to respect it. And the requirement that the decisions of the CCF need to be reasoned has also been codified now, which is also improving transparency, obviously. With regards to the structure of the CCF, it has 2 chambers, the supervisory and advisory chamber and the request chamber. The request chamber is the most important chamber for the persons concerned by Interpol red notices or diffusions, because that is the chamber that will deal with the requests for deletion or requests for access to Interpol's files. And the secretariat is, secretariat of CCF. To give you an idea who is sitting on the CCF, so they're elected by the General Assembly. The General Assembly consists of 1 member, 1 vote. So 195 members. And the CCF currently, can you see this now?
Yeah, I think it should be it should be visible. Yeah.
Yeah. Okay. Consists. I try to make it a bit bigger. Is composed, the request chamber and also the supervisory and advisory chamber are both headed by an American lawyer with international criminal law experience, Teresa McHenry, and the request chamber further has lawyer from Lebanon, lawyer from Morocco, from UK, and from France. The countries are quite important in this respect, because obviously when you want to challenge Interpol red notice or diffusion, you want to hold on. You want to know which country it is from, and when it's from one of the countries that are heading the CCF request chamber, you may that may have an impact on your chances, although it shouldn't have, of course. But I wouldn't think it's not irrelevant. Now, what are the remaining challenges after telling you how much this new reform of 2016 brought us? So positive is that you have, for instance, on the website, you have information for the applicants on the procedure, how to access Interpol's files, how to lodge a request, what formalities you have to observe, etc. You have now the timeframes introduced, and the CCF decisions are also published on the website. Let's say excerpts of the decisions are published. But the backdrop is that the application procedure is still very formalistic. For instance, you need to mail everything to Interpol via regular mail or via registered mail, and that includes originally signed documents. Your client has to sign a power of attorney, has to sign the letter by hand and send it by registered mail to Interpol. One time, I asked the client to sign his power of attorney directly to Interpol in order to make it quicker, and Interpol said they never received it. So it's very important to observe all those formalistic requirements, and this has become especially hard during the pandemic, because obviously mail services didn't work as well as before. The CCF has since the pandemic has reserved themselves the right to communicate via email, unless the applicant doesn't want to. But on the other hand, if someone wants to file a request, it is not permitted per email, still not. With regards to the timeframes, it's good that they have been introduced, as I said, but there's not really a sanction or a mechanism if the timeframes are not respected. And it's good that the CCF decisions are published. However, they're redacted very strongly. If you look at the website of the CCF, I don't know if you will have time for that, you can check the decisions, and you will see that not only the names of the applicants are redacted, but actually also the country that issued the red notice, and a lot of other information that's quite relevant to understand why the CCF has taken that or that decision. So it's obviously in order to keep relations good with all the members, but it's impeding transparency, and it's impeding possibilities of also assessing whether your chances of success when challenging red notices. Okay, that's it as a brief introduction. If you have any questions or comments, feel free to contact us.
Yeah, I just
thank you.
I'd like to add I'd like to add a couple of things to what Anna has just has just said about the commission. So since we're talking about the CCF case law in regard to Article 2 other provisions of the Interpol rules, it's important to remember that the Commission's decisions, the Commission's interpretation of Interpol's rules, whether it's the Constitution or the rules on data processing, they can be, so the excerpts of its decisions that Anna has just mentioned that are published on the Commission's website are not really the only source where you can find its interpretation of its application of the Interpol rules. Interestingly enough, you can find some of those in the Commission's annual reports as well. And not all of them, but some of them contain its understanding of certain Interpol's rules. It's important to remember that the excerpts are not the only source, as I said. And Anna has rightly mentioned that the Commission does redact its decisions. There is a justifiable, I think, at least one justifiable reason for that, because it wants to protect the privacy of the individuals involved. But at the same time, it redacts the names of the countries that potentially engaged in the violation of in the violation of Interpol's rules, which you can also interpret as a justifiable reason, because if they can argue, the Commission can argue that if they don't do that from the circumstances of the case, it might be possible to establish who the victim is or who the other individuals involved are. Also, in terms of the reforms that were carried out in 2016 and 2017, in my opinion, and Anna has mentioned Fair Trials International, the advocacy organization headquartered in the United Kingdom, that before the reforms, there were literally very few lawyers on the Commission. So most of the members, it was unclear if they had any legal experience or legal education. Nevertheless, they were adjudicating these complaints from individuals affected by Interpol's involvement in their cases, adjudicating their rights, which didn't really make a lot of sense. So the reforms did change that. Now the Commission consists of lawyers with expertise in different fields of including international law and police cooperation and human rights and so forth. That was an important change. Also, the Commission Secretariat has staff that has the experience that's supposed to be there to adjudicate cases like that. In terms of the Commission's annual reports, again, in my opinion, it's a very important source if you want to know more about the Commission, its activities. They're not, in my opinion, transparent by any means, and we will talk about Interpol's transparency, to be more precise, non-transparency, during our future webinars. But the Commission does express its concerns about its activities, especially the lack of resources. And it's done it consistently throughout the several most recent reports that it has published. Let's move to our Q&A. So the first one was, I apologize in advance if I'm mispronouncing our audience their name, so please forgive me if I do. There is a question from Thomas Zach. I have a problem with enforcing the international police cooperation. An international police cooperation request in Liechtenstein. So I'm not sure what exactly you are trying. So first of all, I have to give this disclaimer. Nothing that we, as we did the last time, nothing that we talk about here should be treated as legal advice, and we're not discussing any specific case. We can talk about these things in general, but I'm not exactly sure what international police cooperation, how it is related to what you're trying to enforce in Liechtenstein. If you're talking about enforcing a red notice or a diffusion against a certain person, usually it's the authorities who do that. I personally have never heard of a private citizen empowered to enforce a red notice or diffusion, any request submitted via Interpol's channels. Oliver QU, I'm not sure if I'm again pronouncing the name correctly, I apologize. How does recent European Court of Human Rights decision in Leo versus Poland affect Interpol red notice from China? I have to confess I haven't read this case. If you don't mind elaborating,
I think what we can say in general is that, as Yuri mentioned in the beginning, human rights are a ban for extradition under Article 2 of the Constitution. Article 2 mentions the Universal Declaration of Human Rights, not the European Convention on Human Rights. However, human rights are taken into consideration also if they're in other instruments such as the European Convention of Human Rights. And so case law like the one of the European Court of Human Rights applying that convention obviously has an impact or should have an impact. I would definitely argue so if I was to have a extradition request from China. And I know this has been a groundbreaking decision with regards to establishing a general standard for national tribunals to evaluate future extradition requests from China in applying the non-refoulement principle.
I see. I see. So
Yeah.
I think that I agree with Anna. In general, the Commission does take the European Court of Human Rights jurisprudence very seriously. They've cited the court's decisions in their opinions in the past. Um, in terms of other decisions, other judgments that the European Court of Human Rights has handed down so far regarding Interpol requests, there have been several cases. One of them was very important, in my opinion. That's, I believe it was WS versus Germany. That was mostly about the principle of ne bis in idem. We will talk about that in again during one of our future webinars. Very extensive and very complicated topic as well. I personally don't think that that particular decision of the European Court of Human Rights has made a huge difference, like any huge difference, to be honest. But it will, I think, have some impact. I don't think it's exactly groundbreaking, that particular decision. In terms of, so if we're talking about non-refoulement obligations in obligation in Liu versus Poland, right? Anna, that's what you're referring to. Is it related to refugees, or because usually when we talk about that obligation, we talk about the Convention on the Status of Refugees. If this is the case, or it's not. If this is the case, then I would refer you to the Interpol's policy on refugees and asylum seekers. That issue has mainly, I would say, it mainly been resolved by Interpol. The policy was introduced in 2014, and first by the Interpol Executive Committee. It was only recently finally adopted by the General Assembly just several years ago, but nevertheless has been in force all this time. And the policy in general says that that Interpol should not be processing information about asylum seekers or refugees. It's fairly straightforward by Interpol standards, let's put it this way. And I think it's been applied pretty consistently by Interpol as well. If I don't, again, I'm not sure how the jurisprudence of the European Court of Human Rights would add much to that. If we're talking about, for example, about the court establishing that red notices from certain countries, from, for example, from China, are often abusive. I'm pretty sure that Interpol is very well aware of that, taking into consideration the number of instances of such abuse. So, is it going to play some, res judicata role? I don't think so. I mean, not to mention that none of this really Interpol doesn't take any of this judgments by the European Court of Human Rights or any of the decisions of the United Nations Human Rights Committee as anything binding, but they are highly persuasive. That's important to remember.
But I think, I don't know about your experience, but I would say Interpol is not proactively amending its policy based on case law of the European Court of Human Rights. That is to say, we cannot expect Interpol to now delete all red notices that may be not in line with the European Court of Human Rights case law proactively. Unfortunately, it should be like that. But what we can expect is that if your client is affected by a red notice that is a problem with regards to human rights, then if you then raise that topic with a deletion request, Interpol will still issue the red notice, probably. But then if you request to delete it and you have good arguments and you can refer to that case law, then it may be, you have good chances of success. Would you
Yes.
agree, Yuri?
Yeah. I agree. I agree absolutely. So, but I think there are a couple of issues here. First is that you're absolutely right. Interpol is not great at at being proactive, even though under its rules it must be proactive. It's an obligation. And again, we will talk about that as well. It's also a very extensive, very interesting topic. How Interpol pretty much fails to do so. And in terms of amending its policies, you're absolutely right. I mean, they are they behind in terms of both, in terms of international extradition law as well. And I think that Interpol, and I think that follows from there's all these public statements, including by the heads of the Commission for the Control of Interpol's Files. I think Interpol is more concerned about data protection laws in Europe. They try to follow that if they do not timely amend their rules, they at least continue talking about this. They trying to convince, the Commission tries to convince the General Assembly that you have to be more cooperative when it comes to requests for access, which Anna just talked about, that these deadlines often are not observed. It's 4 and 9 months deadlines because governments just don't cooperate. They refuse to cooperate, and that's why it sometimes takes the Commission longer to process this request from individuals. And the Commission has been drawing the government's attention to this issue, saying that you have to understand that for Interpol to maintain its immunity, it has to provide individuals with the due process mechanism. By not responding, by not cooperating, you undermining that, and you putting Interpol in danger. So Article 3. Thank you very much for Oliver. Thank you very much for elaborating on this. So Article 3 of the ECHR, I'm going to read it out. No one shall be subjected to torture, inhuman or degrading treatment or punishment. So Interpol has opined, as I mentioned, in terms of Article 2, it has opined the Commission on the application of the United Nations Convention against Torture. So, I mean, it seems like that particular decision, which recognizes that in that particular case, because the CAT, the Convention Against Torture, is usually fact specific, usually depends on the circumstances of a particular case. I don't think that Interpol will take it again as a solid preclusive element in deciding any future cases from China. Again, if I argue the case about China against China, I'm sorry, and the CAT was involved, I would still try to explain, and present the client's case in more detail and explain why it falls under the convention, as opposed to just citing that decision from the ECHR. I don't think it's really precedent for them.
I think, yeah. I must admit, I also don't know the decision in detail, but if I'm correct, the argument of the applicant was mainly his Taiwanese nationality. So the specialty of this case law was that based on the Taiwanese nationality, they assumed a risk of Article 3.
Right.
I think
because it's a Taiwanese.
Normally, they would assume it because of the death penalty in China, or torture, or Falun Gong practitioner, political dissidents, etc. And being Taiwanese as such was sufficient to have that argument, because
Yeah.
it's serious enough at the moment in China to be Taiwanese apparently.
Yeah. So it's probably, I think that in that particular case, when we talk about Interpol's goals, we'll probably invoke both Article 2, that is the Convention Against Torture, in the context of Article 2 of the Interpol Constitution, and Article 3 as a predominantly political case, potentially
Yeah,
because it's a Taiwanese citizen. Thomas, just in case the relevance of this question will be reevaluated.
I'm
Can you
not able
please
to click on the link, to be
Yes.
honest.
Can you please text us in put us in chat what exactly you mean by this? What's on those web pages, because we can't elaborate. But in terms of this judgment of the European Court of Human Rights, I think that again, the fact that the European Court of Human Rights has indicated that China is is going to, or is likely to persecute rather than prosecute and commit flagrant human rights violations against any Taiwanese citizen. I think I think it's a good point to make or it would be a good point to make in a complaint filed with the Commission for the Control of Interpol's files. I would definitely mention that in any case, if I was, or almost any case, if I was representing an individual in that particular situation. Again, it's not binding on Interpol,
Yeah.
but I think it will still be highly persuasive. This case is not based on specific case, but in general situation in China. Yeah,
Okay.
that's basically what we're talking about. Then, thank you. Yeah, so basically, if it's just in general, again, I think that Interpol would definitely take it into consideration. But again, because it's general, Interpol's is, I'm sure it's very well aware of China's approach to using the Interpol's channels and just in general human rights. If
But
it's important to remember and that it's so I guess obvious, and it's so key to Interpol is that if you yeah, and go ahead, sorry. If
I
you
think a
Yeah, go
I think
ahead, go ahead.
a problem could be that Taiwan is not member of Interpol,
Yeah,
whereas
well,
China is.
right,
So
right, right.
maybe this will not be so easy to fight this case based on this membership situation. I could imagine it. In general, I would agree that um, there is a real risk in case of extradition to China, and it's so obvious that we discussed that we had no doubt about it. But based on the specific membership constellation, Taiwan is one of the very few countries who's not member because it is not recognized as a state by China. Because
Yeah.
of this, yeah, it would be very interesting to see how Interpol, how rule of law oriented the CCF would be in such a case.
Well, Taiwan was expelled, since we mentioned that, because of China, right? Even though,
Right.
uh, I mean, if we look at major human rights and advocacy organizations compiling these reports, and even our State Department, United States State Department, on human rights situations in different countries. I mean, China and Taiwan, it's like two different planets, obviously, right? Taiwan is clearly a democratic country, whereas China clearly isn't. But nevertheless, China is a member and Taiwan isn't. Yeah, Interpol membership is again a separate subject we're going to talk about. It's also a very interesting topic. But I just want to finish, if I may. So because it's in general, it's like a general conclusion. Interpol has pointed this out. It's very important to remember when you prepare a request on behalf of your client, a complaint. Interpol wants to see specifics in terms of a case. It wants to see how your clients were violated, rights were violated specifically. Usually, referring to the situation in general is not enough. So, in other words, I mean, you can do both, but if you only concentrate on human rights violations in general in a certain country instead of concentrating on your client's case specifically, Interpol might not really care about that much. Again, if you look at the cover page, the application that you have to submit with your complaint, this form that you have to fill out, Interpol mentions in that application, it's their form, that you need to concentrate on the specifics of a client's case, as opposed to on general information about the country's human rights violations in general, or its judiciary, or so forth. And yeah, please go ahead. I interrupted you. I apologize.
I, no, I just thought to answer to Thomas Zach a bit, because I think there's a misunderstanding. Interpol itself cannot enforce any red notices. Interpol is just kind of a communication channel for red notices that are then enforced by the authorities, the national authorities of the various countries. And there are many countries that have the nationality ban. That means that they say we do not extradite our own nationalities, our own citizens. And Liechtenstein seems to be one of the countries that do that as well. Germany as well, by the way. We do not extradite our own citizens except for European arrest warrant cases and international criminal court cases. And if you seek cooperation with a country that has a similar regime, then you have to accept, respect their laws. And apparently, if they do not extradite their own citizens, that's the case.
But the may I just jump in really quickly? So Anna, what Anna just again rightly mentioned, the fact that a country does not, Interpol has been very clear on that. The Commission specifically has been very clear on that. The fact that the country does not extradite its own citizens is not a reason for Interpol to delete a red notice or diffusion. So it
No,
is nothing.
no.
Yeah, it's not going to help. Yeah.
No, but
Thomas,
Interpol is in any way. This is a very general misunderstanding on Interpol. That's why I think it's very good that you put the question, and that we can maybe remove that misunderstanding. Interpol itself is not a police. Interpol is called police organization, but they are not. They have no executing powers. They will not go and arrest somebody. Sometimes even in crime movies, they broadcast this wrong understanding, and then somebody from
right.
Interpol or Europol comes and arrests someone, and this is completely
No,
bullshit. They're not able to do that, and the only people who can implement such or execute such a request, it's only a request from one country to Interpol, and Interpol only disseminates that request amongst its members or amongst certain members, depending on how it is requested. And this request has to be then executed by the authorities of the specific member states. And that's why also, I think that's why Yuri didn't quite in the beginning understand what your question was, Mr. Zach, because this is really up to the national authorities, and it has nothing to do with Interpol. Then Interpol is not in charge of making these arrest warrants work.
Right. Yes, thank you, Anna. Yes. That's all. These are great points. Interpol is not going to enforce a red notice. It's absolutely true. As a matter of fact, at some point, I believe it's still on the Interpol website. Not that long ago, they decided to put it on their website. It wasn't there all before, all this time. That Interpol isn't looking for anybody. Interpol isn't seeking to extradite anybody. Interpol doesn't convict or accuse anybody of any crime. Interpol is, in this context, it's pretty much just a database. It's just a way to communicate. So there will be, as Anna has rightfully mentioned, there is no police force with Interpol insignia running around the world arresting people. It's up to a country to decide whether to enforce act on an Interpol alert, a red notice, or a diffusion. And if they don't, then they don't. Interpol can't force them. Then it's sort of like it's up to the country where the individual is located and the country that's seeking that individual's extradition. So in your case, if Liechtenstein isn't cooperating because if it's the country's citizen and Liechtenstein doesn't extradite its citizens, then that's how it is. It's again, Interpol is sort of like beyond Interpol at that point. And it's not that unusual. There are many countries don't extradite their own citizens, and even if an individual is on the international wanted list, in the Interpol database to be more precise, then it's just that. I mean, they might they might maybe ask questions, or try to talk to that person or communicate with that person's lawyer and maybe inform them. And again, that doesn't happen all the time, that the individual is in the database. There have been cases in which I think probably virtually in all cases, a government does not inform its own citizen that that citizen is in the database. I mean, it usually doesn't happen. I'm not a criminal lawyer,
Okay.
yeah,
No
okay,
worries. It's,
I guess that concludes the question.
I hope the question has been answered now to your
Yeah, I think we
satisfaction.
answered it. So I think that thank you very much for all the questions, and I think we sort of went beyond our time limit that we set for ourselves. But it was very interesting. Thank you, Anna, and thank you, our audience, for all your questions. We are looking forward to having you here again during our next webinar. We next time we will talk about how governments communicate via Interpol's channels, and why abuse is possible. How governments are able to use this loophole in Interpol's rules and in Interpol systems to communicate, to disseminate abusive requests, red notices, diffusions, and other requests as well. Again, thank you very much, and we will see you next time.
Thank
Thank you.
you, Yuri, also for the invitation and for setting this up.
Of course. See you next time. Bye.